Hi folks, this is Steve Marlowe from Marlowe Law Office talking about Chapter 13 bankruptcies. There are two types of bankruptcy protection available to consumer debtors in the United States. They're named after where they appear in the United States Code, which is our collection of national laws. Title 11 of USC, Chapter 7 and Chapter 13 are where our bankruptcy statutes are located. First thing that we need to talk about is the means test, which determines whether you belong in a Chapter 7 or a Chapter 13. If you have passed the means test, you can file under Chapter 7 of the Bankruptcy Code. If you make, in the 6 months prior to filing, less than the state's median income, that means you've passed the means test. You need to have made that median income for a family of like size. So if you have a family of 4, you need to look at the state's median income for a family of 4, and if you make less than that, you are presumed to not be abusing the Bankruptcy Code if you file a Chapter 7. Otherwise, you'll probably need to file a Chapter 13 case. Some debtors who don't have to file a Chapter 13 case choose to do so anyway because they want to save property, avoid foreclosure on their property, or they have ethical or religious reasons to want to repay some or all of their debts. The Bankruptcy Reform of 2005 requires debtors to take 2 credit counseling classes if they're going to seek bankruptcy protection. The first bankruptcy credit counseling class that you'll have to take is required to be taken before the bankruptcy case itself is filed. The second one is taken after the 341 meeting of creditors, which we'll discuss in a moment. In Chapter 13 cases, the classes are usually conducted online or over the phone and cover such matters as ledger keeping, budgeting, living within one's means. And the last credit counseling class in some jurisdictions is actually conducted live by the Chapter 13 trustee. Chapter 13 bankruptcy is called a wage earner's plan, in the expectation that individuals with regular income will work with the court and the trustee to craft a plan to repay some or all of their debts. So used, the Chapter 13 helps creditors recover some of what's due them, and help creditors help debtors keep property that might otherwise be liquidated in a Chapter 7, like a house that's being threatened with foreclosure. Yes, you have to go to court, or you have to go to a hearing. It's not necessarily held in a court. Sometimes it's in a courtroom, sometimes it's just in a meeting room. We call this the meeting of creditors, or a 341 meeting. This meeting fulfills the due process requirement of the U.S. Constitution, allowing creditors an opportunity to appear and be heard before the court extinguishes their rights to collect on debts they could otherwise come after you for. The trustee also will question the debtor as to the nature and extent of his or her estate. Unsecured creditors, like credit card companies, rarely show up. The meetings often last less than 10 minutes. The most unique thing about a Chapter 13 is that instead of extinguishing your debts completely like a Chapter 7 does, what we do is we develop a plan that is an agreement between us and the trustee and the court to repay all or some of your debts over a 3 to 5 year period. The trustee, instead of being a person who evaluates your estate and tries to liquidate it in a Chapter 13, receives a monthly payment and distributes that money to your creditors depending upon their status as secured or unsecured or priority. Unsecured are like credit cards. Secured would be something like your house where there's a piece of property attached to the debt. And priority would be something like child support payments. Plans in a Chapter 13 bankruptcy last between 36 and 60 months or 3 to 5 years. In no case will they last longer than 60 months. If you make less than the state median income, the plan can be anywhere between 3 and 5 years. If you make more than the state median income, they'll probably expect you to be in the plan for 5 years so you can repay as much to your unsecured creditors as possible. Chapter 13 allows, in most cases, especially when a debtor is paying back 100% of unsecured debts over that 5 year period, to keep houses, heirlooms, automobiles, that sort of thing. Chapter 13s allow debtors to keep all of that property by making these regular payments. The good thing is these regular payments often result in a reduced rate paid to unsecured creditors, while also protecting you from lawsuits, garnishments, and collections through the operation of the automatic stay. Chapter 13 is superior to Chapter 7, especially for foreclosure defense, because it allows debtors to make up any arrearage on that property over the 3 to 5 year period, while at the same time bringing mortgage payments up to speed and keeping them current. Chapter 13 also allows something called a super discharge of taxes and other debts which normally would not be dischargeable under Chapter 7. The super discharge is of a great benefit to a lot of debtors, especially those that find themselves owing tremendous amounts of unexpected debt, sometimes to creditors like the IRS. The other thing that is important to keep in mind about Chapter 13s and makes them extremely advantageous to many debtors is Chapter 13 allows us to strip off unsecured second mortgages. So if you have a second mortgage on your house, which is on a house, or if your house is worth less than the amount of the first mortgage, the second mortgage can be completely eliminated as unsecured debt, or it can be included as unsecured debt and paid at that drastically reduced rate. This can be a tremendous benefit to people who are underwater on their mortgages. You'll still have to pay things like child support, alimony, some kinds of taxes if you don't get that super discharge or you're not eligible for it. You'll have to pay any awards that you owe for death or personal injury related to drunk driving. Most student loans are non-dischargeable. You'll have to pay criminal fines, penalties, and court costs, and any undischargeable debts from a prior court case, prior bankruptcy case. If you're facing bankruptcy and you have further questions or you need to talk to an attorney, please call our office here at 506-0505. That's 937-506-0505. Or just click the link at the bottom of your screen for Marlowe Law Office at http://marlawoffice.com. Thanks.